penalties are actual criminal incarceration. If you engage in this conduct or you possess this prohibited item, you could theoretically have your liberty deprived. Now, before we begin with this discussion, this video is sponsored by the USCCA. And they're doing a contest right now. It's one that you can participate in. You're going to want to click on the link that's embedded in the description below. They're giving away something fairly cool. I'll give you a hint. It can fit in your holster. Let's talk about this case, Hardin versus the Bureau of Alcohol, Tobacco, and Firearms. A little backstory on this. You may remember that the Bureau of Alcohol, Tobacco, and Firearms changed their position as it relates to bump stocks after the tragedy that occurred in Las Vegas. Now, a bump stock is a device that you can place on a semi-automatic firearm, a rifle specifically, that allows it to operate at a greater rate of fire. I won't go into the actual mechanics of a bump stock, but suffice to say it can turn it into something that somewhat resembles, as far as the rate of fire is concerned, an automatic weapon. Now, I say that with a context, okay? I know a lot of you are probably going to take me to task, but it does allow for a more rapid rate of fire, okay? Let's just leave it at that. In any event, the Bureau of Alcohol, Tobacco, and Firearms for about a decade had construed bump stocks specifically as tools or accoutrement that did not elevate a weapon to the status of being a machine gun. All right, now a machine gun is heavily regulated, as I'm sure you all know. After the events that took place in Las Vegas, they changed their mind. Now a bump stock was, in fact, an item that effectively readily converted a semi-automatic weapon into a machine gun. Well, there was a gentleman named Hardin who owned a number of bump stocks, and he didn't like that ruling, so he sued. And this went up now to the Sixth Circuit Court of Appeals. The Sixth Circuit Court of Appeals did two things that I think are very, very instructive. The first thing that they did, which is kind of amusing to tell you the truth, they essentially negated something referred to as the Chevron defense. Now, this has nothing to do with Second Amendment law, but it is important from a structural aspect when we engage in any form of regulatory litigation. So what's sometimes referred to as Chevron deference comes from an EPA-related suit, Environmental Protection Agency-related suit. Essentially, what it says is that if you have an administrative agency that creates a rule or a regulation, okay, something that's not Congress, we're talking about an executive agency, okay? We don't elect people other than the President of the United States. We don't elect people into federal regulatory agencies, right? So if you have a regulatory agency that comes up with a rule or a standard or a regulation, then that standard or regulation should be given great deference by the court in analyzing whether or not a violation has in fact occurred. Absent a federal regulation or even a federal administrative agency, then the court just simply looks at the underlying criminal statute that has been promulgated by Congress. Again, we're talking about federal law right now. So the Chevron deference has always been, at least in my opinion, fairly problematic, okay? The whole concept of the way that our criminal justice system has been designed is that a law, any law, is by definition a restriction on your individual liberty. Now, we sort of intuitively know that, right? If there is a law that prohibits me from engaging in, let's say, murder, okay, that is by definition a restriction on what I can do. Now, arguably speaking, that's probably a good restriction if we want to have a functioning society. But if we're going to be philosophically consistent, anytime the government says you cannot do this thing, all right, regardless of what benefits to society we're able to achieve, that is by definition a restriction on our individual liberty. And our country was founded on the idea of maximizing our individual liberty. So the framers, in a genius concept, decided to take the entire restrictions on liberty area and place that in the legislature. A legislature is a deliberative body that requires some level of political animation by all of the participants in the legislature to pass a law. And every time a law is passed, it requires collaboration among oftentimes competing parties in the legislature. And by doing that, it lowers the extent of that law, right? If you've got one person who wants to pass a law that says you can't drive more than 55 miles an hour, and it's going to require a whole bunch of people to vote on that, they have to lobby these other legislators, these other Congress people, to agree to that. And in that lobbying, you're going to have other Congress people say, you know, the people that are in my jurisdiction are not going to be comfortable with that law. Maybe we can make it 65 miles an hour or something to that effect. And as a result, the draconian nature of the law is reduced. Okay, so the concept, or at least the theory, is that a law that ultimately gets voted on is going to be the least restrictive in order to still obtain the societal objective. At least that's the idea, okay? The problem is that when Congress abdicates their responsibility and gives an executive agency the ability to develop rules and regulations that are outside of the deliberative legislative process, you now have a group of unelected people without having those political constraints that manifest in Congress coming up with their own rules, which by definition restrict our liberty. So the Chevron deference, like I said, I've always found to be very problematic. In fact, to be absolutely truthful with you, the idea of legislative or executive rulemaking, I've always found to be very problematic. I think this should be completely in the purview of Congress. Okay, all that notwithstanding, in this particular case at bar, in Hardin versus the Bureau of Alcohol, Tobacco, and Firearms, the ATF said there is no need for a Chevron deference in this particular thing. The law is unambiguous. There's no need to interpret our individual rulemaking. A bump stock is the functional equivalent to a machine gun part. Now, Hardin, interestingly enough, also didn't raise any sort of issue with Chevron. They said, no, bump stock by definition is not a machine gun part. The court sat there and said in their ultimate opinion, yeah, we really can't rule on Chevron because neither of the parties really talked about it. But you know what? We're going to talk about it anyways. And we're going to essentially sit there and say that this case is not appropriate for a Chevron deference because, and this is the important concept, because the penalties are not just simply fines and things like that. The penalties are actual criminal incarceration. If you engage in this conduct or you possess this prohibited item, you could theoretically have your liberty deprived, all right? And that is not for an executive agency to come up with that type of standard. That is fully the purview of Congress, and interpretation of that statute, that is going to simply be reliant upon the courts to make that determination. Essentially, they're pushing the executive agency out of the equation in its entirety. Now, whether or not you're particularly interested in owning a bump stock is irrelevant, okay? The fact of the matter is this concept, this idea is extraordinarily important because it could very well manifest in other regulatory environments. Ironically, not just stuff related to the Second Amendment. This whole concept, especially if it takes fire outside of the Sixth Circuit, this could actually really constrain executive actions and executive agencies, for that matter, across a broad spectrum. So that in and of itself is very, very interesting and something that we're going to have to watch later on. But then the court pivots and they come up with their reasoning on why a bump stock is not, the possession of a bump stock rather, is not a criminal offense, specifically because of something referred to as the rule of lenity. Now, this is another philosophical concept that also is consistent with the idea that the legislature actually makes the laws. So if a law exists that is ambiguous or it's vague, sometimes we'll even refer to it as potentially being arbitrary and capricious, okay? But if a rational person could look at this and say, all right, well, this law says that I can do X, but Y is clearly outside of the scope of my prescribed conduct, okay? Unless it specifically states that Y is outside the scope of prescribed conduct, you're allowed to do it. Our laws in the United States are what are sometimes referred to as negative laws. The government does not give us permission to engage in conduct. The government simply can articulate what type of conduct is specifically restricted. Okay, we don't beg for permission from a magistrate. We don't ask for permission to do something. If we're unclear as to whether or not what we want to do is legal, we can, we consult the penal code or we consult the U.S. code, and we sit there and we say, okay, does the government specifically state with clarity that what I want to do is illegal? If they are silent on it, then it is assumed that we can do whatever it is we want to do. That's sort of how our country functions. And this would be, in contradistinction to, say, a pre-Soviet environment in Eastern Europe or the Soviet Union. If you wanted to do something, you had to seek out an apparatchik in the government to get permission to do a thing. Ours is completely different, okay? Arguably, that, again, goes to the idea of maximizing individual liberty. So if a law exists that does not specifically prescribe a type of conduct, then through this common law doctrine of the rule of lenity, we cannot hold the individual defendant liable for engaging in criminal conduct, okay? The government has to articulate with specificity that you cannot do this thing. And in this Sixth Circuit Court of Appeals, the government, or the court rather, comes to the conclusion that Congress has been silent on bump stocks. There is no specific law that says thou shalt not own or possess a bump stock. All right, and because there has not been this conclusive determination, Mr. Hardin wins. All right, he can continue to hold on to his bump stocks. They are, by definition, not a machine gun. Now, the case itself also goes through a somewhat detailed analysis of what a bump stock is, and it definitely leaves the door open for future congressional action to restrict bump stocks. They really don't go through any level of a Second Amendment analysis on this because they really don't have to, right? This case right now is not at the point where they're discussing whether or not a bump stock falls within a Bruin analysis or anything like that. What they're looking at, and they're saying, no, on a much more fundamental level, on the way that our legal system is structured, the ATF actions essentially violate our entire concept of jurisprudence. Anyways, it's a good decision, and I definitely encourage you guys to keep an eye on it. I'm sure it's not the last we've heard on it. And it most likely is going to, like I said, manifest in other areas of law, not just relegated exclusively to the Second Amendment. Anyways, guys, if you need to contact me for any reason whatsoever, you certainly can do so by emailing me at Stephen at artemishq.com. That's our company website. Again, our company is the Artemis Defense Institute, and our website there is artemishq.com. Thank you guys for watching the video. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
It's a true story of self-defense. We interviewed an armed Lyft driver who was carjacked to help answer these questions. Should I carry a gun while driving? And what does a carjacking actually look like? Just click the video next to me to watch this must-see interview.